A third-degree assault in Minnesota is a felony which carries a maximum of a 5-year prison sentence and a $10,000 fine. To be guilty of third-degree assault, the prosecutor has to prove two things beyond a reasonable doubt. First, they have to prove that you intended to assault someone, and second, they have to prove that you caused substantial bodily harm. So for intending to assault someone, obviously it has to be intentional, and you either have to intend to cause fear of bodily harm, or you actually have to intend to cause harm on them by hitting them or something. In Minnesota law, you don't have to actually intend that the injury be substantial bodily harm to be guilty of third-degree assault. So, for example, if you intend to just slap someone and all you're thinking is you're going to hurt them on the face for a second and leave a red mark, but instead when you slap them, their whole face gets cut up and they have to go get stitches, that's a third-degree assault. Even though you intended only for them to get a red mark, instead they get cut open and you never meant for that to happen, you can still be guilty of third-degree assault because you don't have to intend the injury, you just have to intend to assault someone, and then if the injury happens and it's substantial bodily harm, then you could be guilty of third-degree assault. So for substantial bodily harm, that's defined under Minnesota law. It usually means things like broken bones, scars, stitches, or a temporary loss of consciousness or the loss of the functioning of an organ. So if you knock somebody out for a while, that could be a third-degree assault because that's substantial bodily harm. If you hit them and you cut them and they get stitches, that's substantial bodily harm. If you punch them and you break their nose or you break their finger, that's substantial bodily harm. For third-degree assault, there are some bad things that go along with it. Number one, it's a felony, and that can really hurt your record. Second of all, obviously employers look at that and they don't like to hire people with felony assaults on their records. Landlords a lot of times won't let people move in after they do a background check if they've got assaults on their records. Schools and coaching or sports organizations won't let you volunteer to do things with felony assaults on your records. Also, you're responsible for out-of-pocket payment, what's called restitution to an alleged victim. So if you injure them and they rack up 15 grand in medical bills, you're responsible if you plead guilty or are found guilty for the restitution to that person. There are defenses to third-degree assault. The first defense, obviously, is that there wasn't any intent on your part. Second, sometimes you can have the intent, but that you're defending yourself or you're defending someone else, either self-defense or defense of another. Necessity and duress are also common defenses to third-degree assault, as is intoxication. Minnesota recently had a case that came out that ruled that intoxication is a defense that can be raised in third-degree assault cases. It doesn't mean just because if you go get drunk that you're automatically not guilty for assaulting someone, but a jury can take your intoxication into account when determining whether you had the intent that's required under the law. So what you want to do is get a lawyer who knows how to defend a third-degree assault case, who knows how to analyze the medical records to see if we can beat the allegation that there's what's called substantial bodily harm in the case, and who knows how to raise defenses that might apply in your case, whether that's intoxication, self-defense, defending someone else, alibi, whatever it may be. Recently we had a jury trial where there was a broken nose incident where my client allegedly headbutted the victim, and we raised self-defense and lack of intent in that particular case, and after deliberating for only about 30 minutes to 45 minutes, the jury came back with a not guilty verdict in our last third-degree assault case. So go ahead and get yourself a lawyer who knows how to defend third-degree assault cases. My name's Ryan Pacyga. I'm at www.arrestedminnesota.com, 612-339-5844.